Hi, this is attorney Joseph Ott. In my last video, I explained the way different injuries are valued in terms of their permanent partial disability according to each injury. In this video, I'm going to explain in more detail the claims process and the requirements that workers must follow in order to retain their claim under Missouri workers' compensation law. In order to do so, I think that we should assume a hypothetical case. For clarity's sake, we will assume the same case that we used for the computation of permanent partial disability in the previous video. Assume that our worker, let's call him Jerry, is a worker at a union job making $15 an hour. When Jerry reaches down one day to pick up a log, he hurts his back. He feels a sudden, sharp pain that can be traced to that particular movement. Jerry decides that he needs to file a workers' compensation claim. It's important for Jerry to know that he must report the claim right away to the employer. Report of injury is a requirement under workers' compensation law, both for the employee and for the employer. This means that if the worker does not report an injury to the employer, they can be barred from the claim. But equally, if the employer does not report the worker's injury, they too can suffer penalties. The report of injury is often litigated because it often happens, especially in construction and other union jobs, that workers do not want to make a workers' compensation claim. They are often harassed or ridiculed by their supervisors for filing such a claim, or they are tough-it-out kind of people and determine that they will allow the body to heal itself. This is never a good idea. As I've mentioned in the other videos, the history of the workers' compensation system has been designed so that an employee feels that they have the right to report every injury that they suffer while on the job. After an injury is reported, the employer has the right to direct the medical care of the employee. This means that the employer must authorize each medical treatment received by the employee. However, if the employee makes a request on the employer for medical treatment caused by the on-the-job injury, and the employer declines to provide that treatment, the employee has recourse to file a hardship mediation. The hardship mediation is an effective tool at getting an employer to comply with the employee's request for medical care. In many cases, the medical treatment rendered to the employee after filing the report of injury is of paramount importance to understanding where the doctor later on will be deriving their conclusion for establishing a percentage disability for permanent partial disability awards. The doctor later on will be required to look at the medical record that has already been established for that worker's injury. So, prior to the worker achieving the most amount of medical improvement that they can, the medical treatment that they receive from the employer, if the employer complies with the statute and directs the medical care, or on their own if the employer waives that request by losing the hardship mediation or by refusing to provide medical care that's necessary. If that happens, all of that record will be examined by the doctor down the road, and that doctor will use the record in order to make a determination as to percentage disability. For this reason, it's very important for injured workers to do two things. Number one, they must report the injury after they have been injured. And number two, they must be aware of the symptoms that that injury is causing and not be shy about reporting those symptoms. As I mentioned before, workers are often afraid of reporting their injuries because they don't want to be seen as weak in some way. The fact is that everybody gets injured at some point, and the whole system has been designed so that workers can get the treatment that they need. But you can't get the treatment if you do not tell the employer about your injury. And likewise, the doctor down the road who is going to be helping our case in determining your percentage of total permanent disability needs to see the symptoms reported in the record in order to bolster their argument.